Imagine sitting in a cafe, pouring yourself a refreshing glass of ginger beer, only to watch a rotting, partially decomposed snail plop directly into your drink. Gross, right? But here is the truly absurd part. If this happened to you 100 years ago, you couldn't sue the company that made it. The law wouldn't let you. This is the story of how one incredibly gross beverage in a Scottish cafe didn't just ruin a woman's afternoon, it completely broke the legal system, invented the modern concept of corporate negligence, and paved the way for every single personal injury lawsuit that exists today. Welcome to Exhibit Absurd. Our story begins on a Sunday evening in August 1928 in the town of Paisley, Scotland. A woman named May Donoghue met a friend at a local cafe called Meadow Café. May's friend went up to the counter and ordered a classic treat, a pear and ice cream, along with a bottle of ginger beer made by a local manufacturer named David Stevenson. The cafe owner brought the order to the table and poured some of the ginger beer over May's ice cream. This detail is incredibly important. The beer came in a dark, opaque glass bottle. Nobody could see what was floating around inside it. And crucially, it was May's friend who made the purchase, a seemingly minor detail that would soon become a massive legal nightmare. May happily ate her dessert, but when her friend picked up the bottle to pour the remaining ginger beer into her glass, something else slid out with the liquid. It was a dead, heavily decomposed snail. May was, understandably, horrified. The sight of the rotting mollusk she had just indirectly consumed sent her into an absolute panic. She fell violently ill, requiring emergency medical treatment. She was diagnosed with severe gastroenteritis and clinical shock. May wanted justice. She wanted the manufacturer, David Stevenson, to pay for his sloppy bottling process that left her violently ill. So she hired a lawyer and tried to sue. This is where the absurdity of 1920s law steps in. Today, suing a company for a defective, dangerous product seems like a no-brainer. But back then, May hit a massive brick wall called Privity of Contract. The law at the time stated that you could only sue someone if you had a direct contract with them. May didn't buy the ginger beer, her friend bought it. Therefore, the contract was between the cafe owner and the friend. But the friend didn't drink the snail, so she wasn't injured and had nothing to sue over. David Stevenson's lawyers essentially argued, "We don't know May, she didn't buy our product, we owe her absolutely nothing." And under the letter of the law, they were absolutely right. May was legally invisible. To make matters worse, May Donoghue was broke. She was a single mother living in poverty. Appealing her case all the way to the House of Lords, the Supreme Court of the United Kingdom, cost thousands of pounds. So, how did she do it? She utilized a rare legal mechanism and officially declared herself a pauper. She submitted a petition swearing she was not worth more than £5 in the world, excluding her clothing. This allowed her to bypass the massive court fees. Her legal team, believing so strongly in the absolute injustice of the situation, agreed to work the entire case pro bono. They were gambling their own time and careers on a case that every other lawyer in Britain thought was a guaranteed loser. Their gamble got them into the highest court in the land, but victory was far from guaranteed. When the House of Lords heard the case in 1932, the 5 judges were fiercely divided. It ended up being a razor-thin 3-2 split decision. The two dissenting judges, led by Lord Buckmaster, were absolutely terrified of May winning. Lord Buckmaster argued that if they allowed a woman to sue over a snail without a direct contract, it would open the floodgates of litigation. He believed that people would start suing over everything, completely destroying the British manufacturing industry. It was a judicial battle between protecting the consumer and protecting the corporations. Thankfully for May, a brilliant judge named Lord Atkin cast the deciding vote in her favor. He looked at the case and realized the law was fundamentally broken. He decided to rewrite the rules using a concept he called the Neighbour Principle. Drawing inspiration from the biblical rule to love thy neighbor, Lord Atkin argued that in the eyes of the law, you must not injure your neighbor. He defined the neighbor not as the person who lives next door, but as anyone who could be reasonably directly affected by your actions. He declared that a manufacturer owes a duty of care to the final consumer regardless of who actually handed the cashier money. So May made legal history. But here is the massive twist to the story that most law students don't even know. The existence of the snail was never actually proven in court. You see, the House of Lords was only deciding if Stevenson would be liable, assuming there was a snail. They were deciding the law, not the facts. With the new law established, the trial was supposed to go back to a lower court to examine the physical evidence. David Stevenson fiercely denied the snail was his, arguing it was a complete shakedown. But before that lower court trial could happen, Stevenson suddenly died. His estate panicked and settled out of court with May Donoghue for £200 sterling, which is roughly £14,000 sterling or nearly $18,000 in today's money. The entire foundation of global consumer protection law is based on a decomposing snail that might have just been a complete scam. Regardless of the truth, the dissenting judges were right about one thing. It was a legal earthquake. Before 1932, corporations were basically bulletproof unless you had a direct contract with them. After 1932, the floodgates opened exactly as Lord Buckmaster feared. By ruling in May's favor, the House of Lords created the modern tort of negligence. This one ruling forced companies worldwide to realize that if their product harms an end user, they are liable. Every time a car company issues a massive recall, every time a wet floor sign is placed in a supermarket, and every time a consumer sues a massive corporation for a defective product, it all traces back to May Donoghue and that disgustingly opaque bottle in Scotland. It is the very reason this case is taught to every first-year law student to this day. The next time you open a drink, be thankful the bottle is clear, and be thankful for the legal precedence of a decomposed snail. If you want to uncover more bizarre evidence from the history of law, hit that like and subscribe button. Thank you so much for listening. Your support really helps the channel grow. We'll see you next time for another bizarre case on Exhibit Absurd.